Can you hear me? Noel, you're frozen. Can you hear me?
I can hear you. Can you hear me?
Yeah, I can. You were frozen for a moment. I wasn't sure if you.
Yeah, my internet connection is unstable. I wasn't planning on doing it here at home, but I'm locked out of the office today.
That's okay.
Is Shadi on?
She's jumping on. She's like, give me 2 minutes. And it's perfect because I see people jumping on. Hi, everyone. Good morning. Perfect because I see people. You can unmute yourself for a moment and say hi.
Good morning.
Good morning. Is that Eric? Hi, good morning, Eric.
Yes, it is.
Morning, everyone.
Good morning.
Hi, Victor. How are you?
Hey, how's it going? Good.
Where's your other half?
She's in bed,
Oh.
so I'm gonna go back on mute.
Okay, say hi.
Yeah.
So Shadi's going to be joining us in a minute, and we'll, this will allow more people to jump on. Thank you all for joining us. I hope you all have your cup of coffee. You're waking up. This is going to be great information. You gotta love this Zoom life. It's great.
We will,
Say that one more time. You cut out. Okay, let's see. You guys, Shadi's having technical difficulties. Hang on one sec. There. Okay, let me. Hold on, let me. Noelle, can you send her? Can you reach out to Shadi real quick? Noelle, can you hear me?
I can hear you.
Will you reach out to
Does
her
she
real
need
quick?
the Zoom link again?
Yes, yes. Oh, let's see. Is she in?
I'm emailing it to her and texting just in case.
Okay, she said I'm in, but I don't see her.
Sorry, guys, bear with us. It's the reliance on technology.
Okay, and oh, she's in, or she's connecting.
I see her. I see her
I
name.
see her.
Oh, finally.
There she is.
I was like, I won't even gonna say anything.
Good morning, Shadi. Thank you for joining us.
Oh my goodness, I almost panicked, but it's okay. Good morning, everyone.
It's okay, you're here. That's all that matters. We really appreciate you being here. So
Oh, I appreciate you all
Good
being,
morning.
shows your commitment to the subject, which I'm very impressed by on a Saturday morning.
well, let's get started. Just so you all know, this is being recorded. Thank you all for joining us. I'm Manya Prasikian with the Nest SoCal Group, and really the intention of today's trust workshop is really to educate our clients, family, and friends on the importance of having a living trust, how to protect your assets, your loved ones, avoid going to probate, And we're here with our trusted attorney, Shadi Saffer. We really appreciate your time. I know you're busy, you have children. So on a Saturday morning to be here at 9 a.m., I hope you have your cup of coffee with you. So
Well, I did ask for it. Hopefully it'll come up soon, but it's not.
There you go.
My pleasure. My pleasure. No, it's
Husband duty.
yeah, trust me, I know everybody's busy. So the fact that you guys are here to listen to me, I feel very humbled and honored. So truly, and I commend you all because it's a subject that's important. I refer to myself as a trust nerd, but I'm an estate planning attorney. So maybe it comes with the, with the position, but thank you guys all for having me. I appreciate you guys, especially the Nest group, for putting on these invaluable Zoom meetings and just events all the time. You guys are going above and beyond for your clients and not just focused on real estate sales and transactions, but really going above and beyond to be advocates for your clients and their families. And I commend you guys tremendously for that. So thank you.
Thank you. So I'm going to let you take over from here, and everyone listening, this is we will, ask whatever questions you want in the chat. At the end, we'll open it up. So this way it could be a Q&A, and let's make it very interactive.
Perfect.
So,
yeah.
Take over, girl.
And, maybe what we'll do too is I might stop midway and see if anyone has any questions. So that way you guys aren't going, oh my gosh, she needs to stop talking.
Yeah, that would be great.
So I've been doing this for 18 years. Maybe I'm on my 19th year. I've had my own law firm, and I think it's important just to give you guys a little bit of background. For whatever reason, I started out in estate planning years ago when it wasn't actually a really hot topic and it wasn't sort of this big area of law. It was just as important, 20 years ago, but it's even more important today. And so I've seen a lot happen in the last 20 years. And now also because of COVID, it's created additional layers of challenges that really people need to know. So one of the things I always like to start out with in saying or educating everyone on is everything I'm discussing is California law based. So if you have a family member living in another state, their rules are going to be different than our rules in California. And unfortunately, I always say this, so if you've heard me speak in the past, it's a lot of familiar information, but this information is so important that I can't repeat it enough, to people that listen. So California is one of the worst states in the nation with regards to probate rules. And probate is sort of a set of rules that guides what happens when someone dies. Okay. And this conversation isn't just about dying. A lot of people go, I'm not really worried about dying right now. That should be something like my 70-year-old parents maybe might need to be worried about, but that is far from true. Actually, I'm very sad to share that 2 weeks ago, my client who passed from cancer 5 to 7 years ago, her daughter passed 2 weeks ago, and she was 38 years old. And she left 3 children, ages 12, 8, and 5. It's always really hard for me to say that. So the silver lining in this situation was there is a trust that's protecting these 3 little children. And I feel really thankful for that part, at least. But the point is probate rules in California is the most strict out of all the nation. And so I think we take a lot of things for granted. So one of the things I wanted to start out by saying is, if you're over 18, which all of us are, if you're over 18, no one has the legal right to make legal financial healthcare decisions for you and to divide your assets when you pass, or even worse, when you're sick, make decisions for you. So I could be a 19-year-old woman standing in front of you, and if I get into a bad, tragic accident, or I get a stroke or a tumor or something, medically happens to me, my parents, who I might even live with, cannot automatically make decisions for me. And that also holds true for couples. So when I say this, people always go, wait a minute, what do you mean my husband or my wife can't make decisions for me? And it's like, no, they can't. So what I'm discussing is estate planning. And estate planning is a series of legal documents that you, the individual, put into place, or a married couple can come together and put into place, that says, look, this is my I love you letter. This is my love you letter to myself and to my family, so that if life happens, I've got everything in place the instructions based on my desires, my wishes, my personal feelings about how things are supposed to take place when I can't make those decisions for me. So if something happens to me, I get to decide if I want a certain type of medical treatment, if I want, my sister to be in charge of that, or do I want it to be my husband? I mean, I could be married, but my husband and I have very, very different feelings and opinions about life, spirituality, or, medical desires and wishes and opinions. And we're finding this true now more than ever, right? There are differing opinions about what someone believes about life support and things of that nature. So it is important that everybody understand that when you live in California, really all throughout the country, estate planning is absolutely crucial. Even in a state where probate rules are super relaxed, everybody needs an estate plan for a variety of reasons, because when you get these legal documents in place, being a living trust and other documents, a pour over will, help, power of attorney for finances and legal decisions, healthcare directives, and so on. These are like a roadmap for your life. And I really look at it as a blanket of protection. So I always make the analogy of health insurance or auto insurance, right? You guys didn't sign up with your insurance agent for auto insurance going like, okay, now I hope tomorrow I get in an accident. No, of course not, right? You get the auto insurance so that if life happens, you're insured, you're protected, right? And so the same holds true for health insurance. Most of us are all insured with health insurance. We do it so we don't have to pay up the wazoo for medical care. But the other reason we do it is for that security, so that if something very serious happens, our health insurance company will ideally cover our medical bills. So we're not going into debt or having some serious situation, or we're not able to get the medical treatment we can and the medical care we can. So estate planning is the exact same way. And the most important component in an estate plan is a living trust, especially in California. Okay, so why? Because people go, oh, they might be sitting here listening and saying, well, I have a will. Why do I need a trust? They're so much more expensive than wills. So in California, if you have any assets over 100, I don't know where they came up with the number, but $166,500, and you don't have things in place to say, oh, this person will get my bank account, for example, or you don't have something on paper that says this person's going to get my home, which is really what a living trust does, then it's all going to go through the probate court system. So I literally could get off this call today, go to the store down the street. Let's just say I'm a single mom and I own this home in my name. Let's say maybe I was divorced, whatever the case may be. Or let's say my spouse has already passed and I'm a mom standing before you with 3 children. And I go down the street to go to the store and I get into a really bad accident and I don't make it back because I die. If I don't have all these things I've worked hard for, my home, my car, my bank accounts, my life insurance, or even just my personal effects, jewelry, my watches, whatever, the guitar behind me. If I don't have that in a plan, in a trust plan, in a living trust plan, my children have to sit back and wait. And this is what's crazy because of COVID, it used to be, a year and a half. Now it's like a year and a half to 2 years before my children can even get the house, get the money. I kid you not, I could have $300,000 sitting in a checking account in my name alone. And if I die and I don't have a living trust to manage it and it goes through probate court, my children will not get that $300 for pretty much close to a year and a half to 2 years. They won't be able to get it to go buy themselves a condo, pay for their whatever. Okay, so it's a problem. It's a serious, serious problem. And it's an important one. And so my elevator speech always, when I say, oh, I only have like 30 seconds to talk to you, or, someone's like, oh, just tell me what I need to know, before, we got to leave. And I go, okay, if you have children, and I used to say minor children under 18, it doesn't matter. If you're listening and you have adult children, you want to protect them properly. So anyone with children so I always say, who needs a living trust? Anyone with children, anyone with real property. If you have real property in California, it's all, to me, when people call, they're like, oh, I'm getting a home. I'm like, that is amazing. Good job. Congrats. Do you have a trust? And they're like, what? It's like, okay, you have to think, oh, I'm going to go house hunting. You need to have a home in place, because here's what's crazy. You could be doing all this, you can be making all this effort in this crazy real estate market to purchase a home, make offers on a home. And I could actually hire Manya and this SoCal Nest group to help me, and we can make an offer on a property. And they accepted our offer, right? And we're in the middle of escrow, right? And we're like, oh my gosh, we found a home, yay. If I get into an accident and I go to the hospital and I'm now in a coma, and I have no estate planning, I've just X'd the entire deal. But here's the beauty. If you have an estate plan with a living trust, a will, a power of attorney, it's actually the power of attorney that will protect my family in this transaction. And it'll allow my spouse, or if I'm not married, whoever else I selected, my parents, my brother and sister, my adult child, to make the decisions, or to have the ability, the legal ability to sign the paperwork to continue closing escrow on the purchase of the property. So that is huge, because there's transactions and things going on, and I get the calls all the time. I get calls from escrow agents, realtors, individuals, and they're like, this is what happened. And by the way, I'm standing in front of you, poster child for this story. My father-in-law, bless his heart, was in a tragic car accident at age 62. He and his wife were in the middle of escrow. They sold their home in California and went to Bullhead City, Arizona. I kid you not, in the middle of the transaction, he gets into a tragic accident and he's in a coma. If we didn't have those estate planning documents, the story would be even worse, right? My mother-in-law right now would be homeless. She wouldn't have had a home to live in. So I'm just trying to drive this home, that if it wasn't for the documents they had, the estate planning documents, the living trust, and the power of attorney document, my mother-in-law could not have finished the escrow transaction to complete the purchase of that home. So these documents are crucial to our everyday life. And when we don't have it, it creates problems. So I'll go back to my elevator speech. Who needs a living trust? Anyone with children, anyone with real property, anyone with money over $166,500, anyone with a business. And maybe you don't have any of these things, but I had a scenario where it was a single mom. She was renting, no business. She did have a minor child, and she had life insurance. And she was like, oh, I don't need anything. I just need the basic stuff. Just give me my healthcare document, my power of attorney, and maybe just throw in a will in there. And I kept thinking, and I was like, wait a minute, Sarah, you have life insurance, right? Yeah. Oh, okay. Well, who's the beneficiary? I already knew the answer. It's her 5-year-old son. I go, but you don't understand. If something happens to you, your son's not going to get the money till he's 18. They're going to block it. Your family has to go through court to get money, maybe for medical. And like, you've just not really protected your child at all. You've created more problems in a sense. So what I did was I created a trust, a living trust for her with all the other important documents. And we went to the insurance company when the trust was in place and said, hey, insurance company, can you please now title the beneficiary of this life insurance instead of Tommy Smith, the son? We want it to be the Sarah Smith Trust. So now what happens is if something happens to mom tomorrow, the money goes into the trust. Her sister, who's the trustee, has full access to manage the money for little Tommy. They could pay for funeral expenses and all that stuff. See, I get the calls where, someone dies. The example of my client's 38-year-old daughter, she died, and I guess they were separated or something. The husband had to put the funeral expenses on his credit card. They don't have any money. So now the mom's trust is going to pay for it, thankfully, but there's a disconnect there, because the daughter didn't have her own estate plan. So, it's a domino effect that people don't realize. And it's something that we really have to be mindful. And I really mean this when I say an estate plan is another one of your lifelines. It's like, I'm born, I'm a new human. What do I need in my life? You know, I need a living trust. It's like one of those things that you need, right? Healthcare, insurance, you know, auto insurance, a home over your head, estate planning, super, super important. If you've got elder parents, even if they don't have assets, you might think, oh, I don't care, I'm not going to listen. They don't need it. They don't even have like 2 pennies to rub together, right? Let's say. It's still going to affect your life if they don't have estate planning, because you're not going to be able to manage their care. You can't even talk to Medicare and say, hey, why didn't you cover this? You can't even go to their doctors and say, hey, I need to do this, that, and the other. They're going to say, well, you need the documents. You need a HIPAA form for medical, right? For access to medical information. You need to be appointed as their healthcare agent. I'm not going to just talk to you. Even if you're the one child of your mom and dad, I'm not going to talk to you. It just, the legal system doesn't work like that. So these documents are crucial for every aspect of our life, not just when we die. I think sometimes people think, oh, you know, I still have some time. And I don't know. Yes, I hope we all have time. You know, I tell my clients, we don't put this in place hoping again, something's going to happen to us tomorrow. Right. I'm excited to share that my new office manager, she's 29 years old, and it was so sweet. We worked on her trust for the last few weeks. And then she's like, so I updated a couple things and I added some of the new information I needed. And she's like, and we're on the calendar, we're set for Monday. And the reason she's so excited is because she never knew about estate planning. She had no past estate planning experience when she started working for us 6 months ago. And she has a little daughter. She's a single mom with a 1.5-year-old daughter. She has a duty to protect that child, right? So about children, if something happens to me and my children ages 14, 9, and 5, my parents live right down the street, but they need the legal documents in place that says Shadi chose who the guardian of her children should be. That is huge. That is huge. So one of the beautiful things about an estate plan is, you know, people go, gosh, you know, here's the 2 things. No one wants to talk about like death and taxes, right? And then no one wants to pay for it. So I always tell clients, you know, they're like, oh, you made it so easy. Thank you so much. And I'm like, well, you did the heavy lifting. You gave me the information I needed and filled out my intake sheet. You took the time to sit here and meet with me, and you wrote the check. Those are the 3 hardest things to do when you want to embark on doing an estate plan and a living trust. I mean, look, most of us would much rather take that money and go, you know, plan a vacation. And I get it. I don't come from a family of attorneys. I'm the first in my family to go to college. I'm first to go to grad school. My mom's a beautician. My dad's a contractor. Like, I get it. It's a definitely an investment of some kind, for sure. But here's the thing. The moment you put your legal plan in place, your living trust plan in place, and you sign and notarize it, boom, from that day on, you've got that like little umbrella of protection. I'm very cheesy about my analogies because I just want you guys to remember. My clients go, well, I was in the bank the other day and I remember you told me about that umbrella. And I was like, shoot, is this bank account in this umbrella? You know, they come back to me and they say those things. It's a blanket of protection. But here's the thing. What people don't realize is the moment you spent that $2,000, $3,000, $4,000, $5,000 on the trust plan, and the reason why I'm giving you that spread is because every attorney charges a different fee. And we could talk at one point about cost. I'm happy to share with you guys my experience about cost, my firm's cost, other firms' cost. I'm a straight shooter. I'm here to help people get their estate plans in place. If their budget doesn't meet our firms, I will still help you get your trust plan in place, even if it's not through my own firm, because I'm passionate about this and I just want you to be protected. But here's the beauty of it. When you execute that estate plan, and if it's a comprehensive, well-done plan, okay, I always tell people, you don't go to the dentist and say, hey, dentist, can you look at my toe? You know, right? You're like, oh, don't let the guy look at your toe, right? Even a physician, you know, you can go to an ear, nose, and throat doctor and you say, I've got this little thing on my toe. And he might be like, I don't even know what that is. You know, like he or she's not going to look at that. Right. So you want to go to a reputable attorney and estate planning attorney to do these documents. But the beauty is the moment you put it in effect and you make sure your assets are under the trust plan, that umbrella of protection, you've just saved yourselves tens, if not 20, if not $30,000 in legal fees alone. And I'll share it with you. Okay. So take someone like me. If something happens to me and I have no estate plan, I am now costing my family legal fees just to do guardianships for my children. Now, here's what's crazy in our legal system. If something happens to me and I didn't have this plan in place, it's not one guardianship for all three of my children. It's three separate guardianships, 5,000, 5,000, 5,000. That's the average cost of a guardianship in California. 5,000, that's $15,000 right there. I'm costing my family because I didn't have one document in place, which is of the pour over will. And in there it says, Shadi wants the following people to be, or this person to be the guardians of her minor children. While they're under 18, this person's to be their legal guardian. So boom, $15,000 right there. Okay, so let's say I went to the store, I got an accident, now I'm at the hospital and something happens to me and someone needs to make decisions about my healthcare. And I don't have the healthcare directive in place. Okay, let's say it's my spouse, let's say it's my sibling, let's say it's my parents, whoever, someone in my family while I'm laying in the hospital has to go to an attorney, call them and say, hey, my sister, my daughter, my wife, she's in the hospital. She's in a coma. She's not able to make decisions and so on. We believe she's going to get out of this, but in the meantime, we're stuck. We can't sign checks. We can't take money out of her personal account or her investment account or her IRA. Her employer's trying to send me some documents for her health insurance that we need to sign, whatever the case may be. We don't have the ability to sign legal documents and make legal and health care decisions for Shadi. And then the attorney goes, okay, well, hire me. The average cost is about $10,000 and I'll move quickly going to court to get you appointed as Shadi's conservator. Oh, and by the way, mom, or by the way, spouse, what's your credit score? And the clients are like, excuse me? Well, yeah, the judge is not going to let you just become Shadi's agent and representative to manage her healthcare and her finances if you don't have a good FICO score. So that's an issue right there, right? It can't just be my spouse because he's my spouse. I mean, spouses have priority, but if my spouse comes to apply to be a conservator for me and he has some assault charge against him because he had a temper one night at the bar and he hit a guy, that judge might think real hard and say, I don't know that he's the right person to manage her healthcare needs. He doesn't seem like someone that, right? Judges have every right to decide who's going to do what. Because here's the thing. When you don't have an estate plan in place and you didn't put these documents in place, when you don't have a plan in place for your life, the court system says, no problem. We got one for you. Here's ours. And trust me, theirs is not exciting. It's not fun. It's nothing you want to be a part of. So you get the idea. So here we are, just with the guardianship, you had to pay money there. And then for conservatorship, you have to go through a whole other process. And again, you're at the court's mercy. What's happening now, which is the worst, is I settled a probate at the end of last year, and the son died here in California and his parents were in Florida. They were in their late 80s. And this is kind of a sad story. The dad died before probate even settled. And the mom reached out to us, and the administrator, the person here that was the family friend that helped be the representative for the court. If it's out of state, there's more cost. If it's, judges want someone in California, because I could control you if you're in California. But if you're out of state, I'm going to make you get a bond and I'm going to make you go through some hoops so that if you run off with the money and don't give the children or the family the money, we can come after you, if that makes sense. So there's a lot of parts to this stuff that makes it even more complicated. And they needed money for the funeral expenses. This couple just lived on, they're old. They're like in their late 80s. And I felt so bad. The administrator's like, Shadi, can I give them something? You understand, everything was done in that case. We were just waiting for our hearing date. That was like 5 months out. Here's the thing. And my team sat around, we're like, could we go? Could we have an urgent emergency hearing? You realize there's hundreds, if not, thousands, if not hundreds of people filing probates, going into court. Our courts are overloaded. You have to be on fire. It's got to be something serious. I've had judges tell me time and time again in my past 20 years, when I went in on an emergency hearing, on an ex parte hearing, the judge is like, why is that our problem, counsel? And I'm like, why didn't he do his plan? Now there's some emergency and you expect me to put him in the front of the line? That's literally the stuff they say to me. I mean, people tell me, oh, we need to go on an emergency hearing. We're in the middle of escrow. I'm like, oh, I've heard that one. They're not going to care because that's you and everybody else. So the judges just, sorry, one of our clients, their escrow fully fell through and they were not able to resell that home for about I think it ended up being almost 8 months later. This is the stuff that happens. And they thought, oh my gosh, the courts, how terrible of them. We have, the sellers, the buyers here, we have everything. Why won't they just approve this document they will not do it. Because if they do it for you and me, they have to do it for the hundreds of thousands of other people. And then where are we, right? It's an inefficient system. So the last thing I'm going to say, and then I'm going to stop so I could give you guys time to maybe ask any questions, is probate is really icky in California. It's public. So when I say it's public, like they'll be like, oh, Shadi owned this ring, this engagement ring, or this. I mean, they can, like, when I die and I don't have a trust. So when I have a trust, it's all private. Nobody needs to know my business and what I'm leaving my children or my loved ones. But when you don't, you guys all could go. I mean, it's hard to look it up, but you can do it if you know how to do it. But the Fast and Furious actor Paul Walker died years back, but everything of his life went through probate. It was in Santa Barbara County. I know because I actually was at the hearing when his case was called at the courthouse, at the actual department. It was exciting at the moment, but what's not exciting about that story is he left a little girl, a little daughter, and she has to wait till 18 to get everything. Everything's controlled by the courts. Here's the craziest part. She gets it all at 18. So I don't know about you, but if someone hands me even $500,000, they're like, here you go. You didn't work hard for this, but here you go, right? Lotto money is what we call it. It gets spent through very fast, and that could be very dangerous. In a trust, you could leave your money to your children or beneficiaries with conditions over time, a little bit of money every year. I have one client recently that was like, you know what? I'm not going to leave my two kids $5 million and I don't want to ruin their life with this money. So he had me draft this condition that if they're his two kids, whatever salary they make in a year, the trust will then match it. I thought that was pretty cool, right? Because his biggest thing was he worked to build this money. He came from nothing and he didn't want to die tomorrow and his two children get 2.5 million. And then he was worried this money would hurt them rather than help them, right? Make them lazy trust fund babies is what we call them. So there's a lot of ways where you could say, oh, you're not going to get it till you graduate from college. You're allowed to do all that stuff. You can leave a little bit you can carve out the money like a pie, a little bit for my aging parents, a little bit for my adult children. Hey, I'm going to create a little college fund for my grandchildren. I don't have any now, no problem. I can create a condition that this money goes to college for my future grandchildren. A trust is an amazing thing. And here's what's beautiful about a trust when drafted right. It gives your beneficiaries, the people you're leaving the money to, not you, the people you're leaving the money to, creditor protection, divorce protection, special needs, disability protection. Why is that so important? Because tomorrow I could drive down the street and really become incapacitated, maybe have to get on disability, and the money my parents leave to me, in a trust, I get 100%. But if they leave me as the beneficiary of their bank account or the beneficiary of their life insurance, or worse, they don't do their plan and I get money through probate, all those other options just boom, disqualified me from my disability. I mean, so if I have a child in the future, a grandchild in the future, and they now are a special needs child, maybe they have Down syndrome or something, I just shot them, I just gave them money but didn't protect it and their benefits, right? So there's so many layers to this that I don't want to dive too deep because you guys are gonna be like, oh my God, does Shadi remember it's still Saturday morning? But it's important. And here's the last thing I want to mention to you. Attorneys, trust attorneys, I make 10 times the money in probate. 10 times the money in probate. From a business perspective, I don't know, maybe I should just sell everyone a will plan or no plan. Because when a client dies, they can only have one home, just a house, just this house right here. Nothing else, right? Let's just say I have nothing else, just a house. And my house, the market value could be $1 million. I could owe the bank 700,000. So my equity is 300,000. Only 300 is going to go to my 3 kids. Probate fees are based on the market value of that asset. So now the fee to my law firm after doing that case for 1.5 to 2 years, and by the way, I don't mean to sound like, I don't want to sound like obnoxious or crass. A lot of my probates, the fee I get is not even worth the time I've spent on it, just so you guys know. But after 1.5 years, maybe 2 years, my firm gets $31,000. It's set per the code. It's in the code book. You can go look it up, put in the value of your estate, and it'll spit out a number. $31,000 when you could have just spent $3,000-$4,000 and avoided all the other issues and everything, and a public proceeding and waiting 1.5 to 2 years. The thing is we don't know what we don't know. People are walking around living their lives. They get that it's important, but they don't really understand why it's important. And then when they know why it's important, it's hard to make the time to do it and decide I'm going to be responsible and write the damn check. Like, that's just the truth. I'm very, very passionate about the subject. So for me, it's an investment in your life, your family, your assets. It's important. If someone doesn't understand the value of saving $50 a month, you're never going to be able to help them save. They have to at one point understand the value of that. And so, by the way, I didn't tell you all the costs for probate. Before an attorney can even file a probate, a client has to pay them $3,000. Why? Because it's for all the costs. There's costs, hard costs, filing fee, publication fee. A lot of times judge asks clients to get bonded. Bonds could be $1,800, $1,300. One of my clients' bond was like $2,100. By the way, that bond is paid every year the case is open. Okay, so if I go into year 2 right when I go into year 2 of probate, my client's paying the additional bond. So then also what's crazy, remember how earlier I said my firm gets $31,000? Well, if I die and I have 3 adult children and only one of them could be the representative with the court. So there's always an attorney and a family member. They get paid. Why? Because it was a lot of work. Right? They're meeting the realtors, they're going to the banks, they're going to the attorney, they're doing a lot of stuff. They get $31,000 as well. So just for $1 million property, market value, equity 300, that probate costs that family 1.5 to 2 years and $65,000. That's crazy. Isn't that crazy? That's just crazy. I remember, I'll say this and then I'll stop. I remember it was like 10 years ago. And I'm embarrassed to share this, but there was an attorney in Leisure World that would just do wills all day long. And I was like, but these people have homes. Like, I was super confused. I didn't really understand. Like, I was like, oh, does he not want to get them to, instead of spending maybe $950 or $1,500, it's hard for him to get these seniors to spend $2,500 or $3,500 or $4,000. I thought that's what it was. Like, oh, they just, they don't want to spend the money. So here's your will plan. Okay. So it's the will, the financial power of attorney, it's all the other documents, but just a will and not the trust. An attorney friend of mine is like, Shadi, you're so naive. Don't you get it? The guy does the will and then his name's on there, law office of blah, blah, blah. And then the parent dies and the kids go back to him and go, oh, I guess we have to go through probate. Here you go. Maybe, I don't know. To that attorney's defense, because I don't want to be like bashing attorneys here. I've talked to a few attorneys in those senior focused communities, and they say they just don't want to spend the money. I'm like, okay. They're like, yeah, I'll let my kids deal with it. I don't even do it. Sorry, I don't. I know I'm crazy, but people call me for a will plan. If they have a property, I go, I'm not doing it. You need a trust. Like, I will meet with them and explain it to them, but I just don't feel like in good conscience that I could do a will plan when I know this daughter's gonna have to turn around and come back and hire us or hire some attorney to probate her dad's home. That's not the kind of money I want to make. So I'm going to stop there and see if you guys have any questions. I ended up talking way more than I wanted to. I'm so sorry. It's a lot of information though.
You can throw your questions in the chat, or you can unmute yourself and throw Shadi a question. I know I have a question that, from the framework aspect of trust. When someone is going to do an estate plan and in setting up a trust, there's a lot of components to a trust, right? So you've got your medical directive, your will, the actual living trust, but you have to assign specific people to specific roles within a trust. Could you kind of give us a quick breakdown, Shadi, about the most important roles people need to be aware of that they're going to have to decide on for their living trust?
100%. I mean, really, you could break it down very easily in like 3 to 4 roles. I mean, there are a lot of different documents, but really what happens is we're using the same people for the different roles, if you will. Okay. Now, obviously, if I have a sister that's a doctor or a nurse, I might say, okay, I want my sister to be my healthcare agent. So that's the person making decisions for my medical and healthcare needs. But then I have a brother who's a CPA and a financial planner. And I might be like, well, shoot, I'm going to have him be the trustee of my trust, because the trustee is the one that manages the assets and distributes the assets. Same thing for the power of attorney. The agent under the financial durable power of attorney makes legal decisions and financial decisions. So really it's 2 major roles. Who is going to decide things for my person, my body, my health? And who's going to make decisions for my finances, the power to sign legal documents, and so on. And it's really 2 major roles. I try to make it super, super easy and streamlined. The only other role that you want to decide upon is if you have minor children, then you're going to be like, okay, and who do I want to take care of and care for my children, right? Those might be 3 very different people, and that's okay. Okay. Sometimes it's nice, right? It's okay to give one person all the tasks. I see it all the time. And sometimes, like for someone like me with 3 minor children, I might not want to have my sister be the guardian and manage the assets. It's a lot. Hey, here's my 3 kids. And by the way, can you also manage the property and the business? That's a lot. Now, when I say manage, the idea is that, if the kids aren't living in this house, maybe the house is rented or it's sold. It's not like she's becoming a property manager. And by the way, agents have a fiduciary duty. They're not supposed to be doing everything for your life when life happens, right? So I talk to trustees a lot, and I feel really bad because sometimes adult children are like, well, I'm the trustee of my mom's trust. And she's like caretaking, filing their returns, doing their finances. And then she's like cleaning out the house. And I'm like, whoa. I'm like, Sarah, you are supposed to hire people to do that for you. You're not supposed to do it all. So when you're a trustee or when you're a power of attorney, you have a fiduciary duty to oversee it, but you have every right to hire professionals to do it. In fact, I really urge my clients, you have to have a realtor to list it. Please, there's no for sale by owner in estate planning. Judges, the probate system, our legal system, when I appoint someone to be an agent in my estate plan, that's a responsibility. They don't care if it's my 70-year-old dad. My dad can't say, sorry, Your Honor, I didn't know. The judge is going to be like, excuse me? They have no mercy. They're going to be like, sir, you should have known. You should have hired an attorney, gotten the advice, hired an accountant, had them file the tax return. You're not an accountant. Why did you file the tax return? Now it's all messed up. You're going to pay for it. They are pretty strict on stuff like that. So the 2 to 3 major areas is health decisions, financial legal decisions, management of all the trust assets and distribution. That kind of goes with the financial part. And then guardians for children. Those are really the areas. That's it. Now, if you want someone else to manage your funeral arrangements and stuff like that, then that's the executor under your will. Okay. And so the terminology gets really like confusing for people. And I apologize for that. The attorneys in the legal system, we never make it easy. I'm always like, can you just keep it simple, please? So you've got your living trust. That's one document. Then when you have a trust, you've got what's called a pour over will, because it's just saying, hey, I'm here, but I'm pouring over into my trust. But the will is still super important. Talks about cremation, burial, guardians of minor children. So you still need a will, okay, when you have a trust. Okay, so when you have a trust, you always need a will. The do-it-yourselfers online, I get the plans and I'm like, where's the will? Oh, I thought I only needed a trust. Well, yeah, you need a trust, but you still have a will that goes along with the trust. This is why these things are so important, right? This is why I don't go do my own oil change, right? Because I'm going to forget the gasket or something, or put the oil in the wrong thing, wrong compartment or whatever. And then along with the trust, the living trust, it's called living trust, revocable trust. Then you've got the pour of a will. Then you've got the power of attorney for financial and legal powers. So durable financial power of attorney or springing power of attorney, there's different kinds. And then you've got the advanced healthcare directive, also called health power of attorney. There's a lot of different names, but healthcare directive, advanced healthcare directive. There's a lot of other documents I'm not mentioning, but those are the biggest, most important documents. In the healthcare bundle, so to speak, you've got your HIPAA for access to medical information. And then you've got your life support document, but it's often called a living will. And I really don't like that name, because if you're sitting here listening, you're going, she just said pour over will, and living will. What the heck? Which one's which? So the point is I always tell clients, whenever you hire someone, it's important to know what they're doing for you for the price. And so I've just packaged my plans in my firm. I don't piecemeal things. People call me, I just need a power of attorney. I just try to refer them to someone else that can help them. Maybe I'll have my office try to help them, but we're not really trying to retain clients like that. We're just trying to do comprehensive plans. So we're doing all of this for you, and this is the price. Some firms still do it on an hourly basis. Most firms now are doing it on a flat fee, like, if you need this, this is how much it is. Now, it's not an all one size fits all, right? Trusts have different components to it. And I won't get into it here because I think it's a lot. So not all trusts are created equally, right? If you've got a blended family and you've had prior kids from a marriage, you're going to need a certain kind of trust. If you are a non-US citizen, or one of your spouse is a non-US citizen, you're going to need a certain kind of trust for tax purposes, death tax purposes. You could be a couple where one is 30 years younger or 20 years younger and the other one's older. You might want a trust where if this one dies, the older one, half the trust is frozen, so the surviving spouse won't remarry and go, here you go, my new lover, Fabio, yeah, my husband worked really hard for all of his money, and I'm going to take half of it and give it to you or to your kids, or worse, I'm not going to give it to my stepchild, right? So there's a lot of different things a trust can do that makes it so amazing. You might be dealing with someone with 3 children, but one of the children's disabled. Please, God, don't leave the money to just the 2 and go, oh, they'll take care of the 3rd. Please don't do that. Trust, protect, clients come to you like, oh no, I'm not going to leave money to my 3rd. They're just special needs. And the other 2 will leave the money for, it's like, what if something happens to one of the other 2? Their kids are going to get it, or their spouse is going to get, that is so messy. Trust can totally protect a special needs child, where the money stays in the trust, the trustee manages it for that special needs child. I've had to spend man hours with clients saying, I could just be like, okay, yeah, I'm gonna forget the 3rd. Let me just leave it to the 2. I could move on with my life in half the fraction of the time, but we don't do that. We position ourselves to be your guide for life, your estate trust advisors for life. Why? Because life changes, stuff happens, and you need to have someone to call and go, hey, Shadi, this is what's going on. Yesterday I got on the phone with a client that was literally getting on the plane. I'm like, John, this, and this, you're fine. You just have to do this one thing and you're gonna be okay. Okay, thank you, Shadi. I'll call you when I'm on the other side. That has value. So I'm going to stop just to see if anyone had any questions. And there is a question here. I have accounts that are available. Ah, okay.
Hi, Shadi. Yep.
Hi. Hi. Han, is
Hi,
that
can you? Hi, yes. Can you hear
Okay.
me okay?
I can, yes, thank you. Thank you for the question. So the question is,
Yes.
so I have financial accounts that are payable upon death, paid on death, beneficiary designated to people. I don't
Yes.
need a trust for these accounts, right? Okay, this is a very good question. So yes, it's great that you have the beneficiaries on there, but what happens if something happens to you and you're in the hospital and you've got these accounts? Who can access those accounts for your care?
My husband.
Okay, so is it a joint account?
He's listed as a beneficiary, yes.
So he wouldn't have any access to your bank account until you pass away.
He has access to all my accounts. But yes, he has passwords, everything.
Yes, but people don't realize when someone dies and the banks find out that you die, they legally can block your account shortly after you die. So he'll get it because you've died now, and he'll get access to it because he's a beneficiary. It's an option. It's better than having no beneficiary on there, but it's not the option I suggest for a variety of reasons. If you guys get in an accident together and he's your beneficiary, now we've actually potentially caused that as a probate issue. Maybe something happens to your husband, you haven't changed things, something happens to you. The question is, who's got access to the account when you're incapacitated or elder? What happens when your husband dies? So the beauty about having a trust as the master plan or the master shield of protection, umbrella of protection, is that you can then just go to the master file, change the terminology, and then it'll cover all your bank accounts. So if your bank account instead had the Chen Family Trust, I'm sorry, I used someone else's name, the Badger Family Trust on there, you understand it's going to flow then down to children, or if something happens to your spouse, to your other family members and so on. So there are some things you have to be mindful of. Also, keep in mind a power of attorney dies when you die. So people go, oh, but I'm my husband's power of attorney, I'm going to go access his account. I'm like, no, it's done. Like the moment that person died that gave the power of attorney, they can't use it anymore. So it's not bad what you did. That's great. I mean, would I want you to have no beneficiary now? No, of course not. I want you to have that because that's what protects you when you don't have a trust. But it's just what I call a Band-Aid. It's not the best option for a variety of reasons.
Okay, thank you.
I'm sorry, go ahead.
No, I was going to say that's very helpful. Thank you. So
my pleasure, my pleasure, my pleasure.
I do have another question, and I probably some other folks on the phone probably do too, so I don't want to take up too much time. But 6 years ago, my dad passed away, and I put together a living will for my mom, and it was all online. So there's LegalZoom, there's a couple of different options that you can go online and just fill out the paperwork. It didn't take me a lot of time. I just had to get documents ready, her social security numbers, family members that would be involved, family members who may want to execute the living will, and stuff like that. So is that the same as putting together a trust?
So the terminology you're using when you say living will is actually the document for life support. So if you're saying that you just went on and just did some basic documents for healthcare and life support, then that sounds right. If mom had no assets or nothing else going on.
She had assets. Her home, her bank accounts, everything would be covered.
So you did a trust. You actually did a trust.
Okay. It was called a living will, but I guess there's a fine line between a trust and a living will. So
yes, it had to have been a trust. I mean, maybe the recollection might not, it had to have been a trust. A will alone would not. Now, unless they died and you went through the probate court system, did you have to go through any court system?
No.
Okay, so it has to have been a trust that you guys then deeded the property into the trust with. Yeah.
Okay. Yeah. But doing it online is same as hiring a lawyer per se then.
If you're very uber diligent and you're not going to miss all the documents you need, and then you make sure you do the deed transfers and then the preliminary change of ownership report. The thing is now things are changing a lot in the landscape. So, sometimes one missing document can have a huge effect on the process, and it could cause a lot of legal issues later and expenses later. So, again, can it be done? Absolutely, of course. The question is it going to be done efficiently and effectively to avoid ultimately those issues down the road? Because the financial accounts have to also be titled properly or beneficiary designated properly under the trust and so on. So there could have been some unique scenario as to why it went smoothly there. Maybe it just was the house and you did it right. You deeded it into the property. It didn't create any chain of title issues and stuff. Because even how you deed the property into the trust and how you do it is very important, because if you don't do it with a clean chain of title, like if it's not deeded properly, it could be a huge issue. I've got a trust right now. I don't know really who they used or how they do it, but I have got one bank, mom and dad are passed away. I've got a bank account with a title of the trust and a property with a different title of the trust. That's going to be a huge issue for us. The bank's like, we're not going to give you access to this trust. Give us the legal documents we need that matches this account, and we don't have it right now.
I can tell you from a real estate perspective, 100%, it makes a difference in a real estate transaction. If that name of the trust is, if the property wasn't recorded with the county recorder's office in the correct name of the actual trust, then you have some pretty heavy paperwork nightmares to deal with in trying to figure out how to sell that property or how to go through the escrow process and do it without expense or getting an attorney involved at that point. So it's crucial that those documents are recorded in accurate names and recorded with the county recorder's office. So you can't just write a trust and then not record the assets under the correct name of that trust. It all has to be done at the county recorder's office. So you can get a trust and have it notarized. That doesn't mean it's your property's recorded in it.
Yeah, so sense. I get a lot of those where they think they have this beautiful plan, and then I had a will not witnessed properly, so we had to go through probate. I had a trust not notarized properly. I had a client that the documents looked great, everything was fine, but the assets weren't all in the trust. Certifications of trust are really important now these days too. There's a lot of moving parts. I've seen them fail more than they've worked is the problem. So you might be uber meticulous, Han, but most of us aren't uber meticulous, and they can't, they don't have the time or the ability to follow through from A to Z. And there's just a lot of moving parts to it. I have some trusts too that are drafted online. And when the person dies, we have to go to court because the trust language wasn't clear on how it's supposed to be distributed, or a unique situation happens and the trust doesn't have enough guidance on how to do something. So we're back in court again. So, it's the adage of you get what you pay for in a sense. So I always tell clients, if you have a home and you have assets worth protecting, it's just a cost. And by the way, when you do these trust plans, you're not having to it's a one-time or just only a couple of time cost in your life. So it's worth the expense of getting it done right with a reputable firm. Could you talk a bit more about the cost range we should expect for hiring a lawyer for estate planning? Yeah, that's a great question, Michelle. So Michelle just asked, what's the price point of an estate plan? If you're in LA, the average cost right now in LA is like $5,000 for a reputable firm to do it, all in, everything included. But you have to understand, this typically are properties with $1 million market value. A lot of times they have a lot of other assets and things. The average trust cost. So in all honesty, for me, anything under $2,500, I get a little bit worried about now. So $2,500 to $3,500 range is a fair range. In my firm, single trust is $3,500, marital is $4,500. That's just our pricing, and it starts and it goes up from there. But when you hear numbers, you have to know what it includes. So all of our plans include the filing fees, recorder fees, notary fees, all of it's built in. So we're not billing the client above and beyond those fees. And then the biggest distinction for us in our price point is you're getting guidance now for free. Unlimited guidance. We're not charging you. So anytime you have questions, need guidance on your trust and your assets, and when you acquire new assets or refinance, we make sure the property stays in the trust. I will share one thing about cost. This last year in February, I got 3 probate cases. They all three hired an attorney. They paid him $1,500 and it still went through probate. So one of them, the business wasn't in the trust. Another one, a bank account was left outside the trust and it had like 300 some $1,000 in it. So right there, they tried to save $1,000 or $2,000, but it just cost him, boom, $12,000 and a year and a half to 2 years to get the asset. So now I'm a little bit more opinionated about do-it-yourselfers and anything under a certain price point, because it makes me nervous, because they're only maybe deeding their home in it, but they're not doing all the other assets. Regarding the assets that should not be included in trust, such as a 401k plans or life insurance absolutely should be in a trust. 110,000% should be in a trust. 401k and IRAs. Every attorney has a different opinion, but right now, in a general sense, a lot of trust attorneys, and I've always done this, 401ks and IRAs should not be beneficiary designated to a trust. They should go right to the beneficiaries. Why? 401ks and IRAs come with very strict tax rules, and they just changed the rules recently, a year or two ago. And now when I acquire my dad's IRA or 401k, the company rolls it into an inherited IRA or 401k now for Shadi. And it's got some new rules that I have to distribute the money out within 10 years. It's so rule-based and tax heavy, the rules, that we just say, let's make sure it goes to the beneficiaries. Now, not minor children. So we have to talk more about that. And there's some backup plans for that till they're 18. But generally speaking, 401ks and IRAs should just be beneficiary designated to individuals and not a trust, generally speaking. Okay. All right. Oh, my pleasure, you guys. I'm getting some thank yous. So I appreciate
Thank you so much, Shadi.
Yeah, no worries. If anyone doesn't have any questions, I'll wrap it up. And I mean, I don't want to take your time. I'm here to chat more if anyone has a few extra questions or anything. And if not, our firm is all about education. We will guide you. We will educate you. We've got a lot of resources on our website at assetprotectioncenter.com. We also have YouTube videos on the subject matters, and we have a whole bunch of CDs, books, and things that we could provide if you guys need it. And we do consults complimentary for clients. So we're always happy to guide you guys. And like I said earlier, if your budget doesn't fit our price point, we will try and match you with another attorney to help you make sure you get your estate plan in place. But thank you guys for taking the time this morning to listen to this very important subject. Please share the information with your family and friends, because so many of us don't know what we don't know.
Right.
SoCal Nest Group, thank you guys so much. I really appreciate you guys for hosting me and for always putting on these awesome events. I appreciate it.
Yeah, thank you so much for being with us. This is a topic that's near and dear to our hearts. It's affected a lot of our clients. We've seen some pretty terrible horror stories out there. So it's super important for us to educate the public at large and our clients about the importance of having your property in a trust. And for all of you, if you have a trust, if you've refinanced, make sure your property is still in that trust, because it happens all the time. So that's a public service announcement for today.
Yes, we're happy to do that for you.
Yeah, we can check it for you for free, no cost. We can check to see if your property was re-recorded into the name of the trust, so that you know that you're protected, because I've seen that unfortunately happen. I know Manya and I have run into that with clients in the past. So that's something that we can definitely do for you if you're curious about that through the title records. We have access to that pretty quickly. And again, we recorded this today, so we're going to send you a link to the recording. We will put Shadi's website in there and her contact information as well, so that you can reach out directly. Our contact information will be there. Manya, anything else you want to add?
That's it. Thank you guys so much. Thank you all for joining us, Shadi. We really appreciate you. This is great information. Thank you.
Thank you guys. Thank you, ladies. Thank you, everyone. Have a great
Thanks
Saturday.
for being here. Happy Saturday.
Yeah, happy Saturday, everyone. Take care.
Bye.
Bye.